proves that A, Section 4B of the Drugs Act is unconstitutional and therefore invalid.
The South African indigenous SONA activists were arrested Wednesday when the police led search into a camp where they stayed near the presidential office in Pretoria. The South African police led a search into the area that was believed to have been used to grow cannabis for over 3 years. The police arrested a Khoisan leader who claimed to a shoulder-height cannabis plant as they dragged it across the presidential lawn in Pretoria. The group's tarpaulin tents have been a fixture on the emerald lawns of the South African president's office since 2018, when they began a campaign for official recognition of their languages. In 2018, South Africa's top court decriminalized the private and personal use of cannabis in a landmark case that pitted law enforcement agencies against advocates of the plant, known locally as Daga.
In a move to bolster an economy ravaged by the pandemic, the South African government plans to formalize the cannabis sector. Our next report tells you the complete story.
South Africa's economy is at a weak footing, and COVID-19 only worsened this. However, government is not wasting any more time to invest in sectors that could help bolster the country's economy. One such industry that the government is eyeing is the cannabis sector.
And lastly, the new sector of the economy, cannabis, the cannabis industry. We want to be the industrial hub. We already have industrial infrastructure. So the processing of cannabis, not to smoke, please. The processing of cannabis, particularly cannabis for health purposes and for other parts of improving the quality of life of humanity.
This is Professor De Beers. He has a valid license to grow cannabis for medicinal and export purposes only. His company will soon commence their first exports. He believes that South Africa has the potential of becoming the cannabis capital of the African continent.
We don't have the potential. We've got the potential. We are going to do it. It's all about the operators. It's about the people that you give the licenses to, and the drive and the passion for cannabis, and our group and the team that we've got and the town that are staying. I think we need it, and we're going to make it happen.
Constitutional Court in South Africa decriminalized cannabis use in 2018. Adults can use, possess, or grow cannabis in private for personal consumption. Public smoking is not allowed. It will lead to paying hefty fine or imprisonment. Adults can possess up to 600 grams of cannabis per person. Professor De Beers is optimistic about the role cannabis can play if the sector is fully legalized.
A small facility like I've got, in its starting shoes, that's one of the biggest in South Africa. It's employing 45 people. In the next 6 to 8 months, we'll probably stand on about 200-300 people, and our plan is to stand on 1,400 people. And this is one facility. Now imagine if you've got 100 of that out there. All of a sudden, you've created 150, 200,000 jobs. 200,000 jobs feeds 1 million people. That's how you build a GDP in a country.
After the ruling in 2018, South Africa saw a lot of cannabis cafes springing up, and this is one such cafe. This 420-friendly coffee shop and nursery is mainly famous for leasing out small piece of land to people to grow their own private cannabis.
is we lease you a small piece of land, 3 by 3 meters, and we effectively help you to grow your own cannabis on your own piece of land. Your cannabis then comes here to your own private club, and here we've got a variety of testing equipment as well as processing equipment to convert that cannabis plant to a medicinal oil or a cream. And what makes our club special is you can actually select your oil or cream, or build that oil or cream with a specific flower with a specific medicinal content that you can see through the lab testing.
According to market experts, Prohibition Partners, South Africa's cannabis market is seen growing at a value of 27 billion rand by 2023.
Some of the experts in the cannabis sector in South Africa is optimistic that this country's weather is conducive for the growth of cannabis plant. They are also of the belief that South Africa has the potential of becoming a powerhouse green economy once the unregulated market is formalized. This is Kalden Ongmo from Vaal Region, South Africa. For WION, World is One.
How's it, gents?
Yeah, good to see you. Ready to go? All right.
Let's go.
So we're back with another one. Exciting stuff, guys. Today we're just going to get a little bit more clarity on everything that's happening in the cannabis space.
In the legal space.
In the legal space. We're being joined with Brett Pollack. Thanks, Brett, for joining us here, man, today. Brett is a professional attorney who's very involved in the cannabis space. So he's got a little bit more clear understanding on all of this stuff. And thanks for joining us, Brett. And do you mind just giving our viewers a little bit more information on yourself and your missions?
Thanks, man. It's lucky to see you guys again and to be here with you. Thanks for inviting me to participate in your lekker content. Yeah, I mean, I was admitted as an attorney in 2014. I'm a regulatory lawyer, so I was practicing as an attorney back in those days at a corporate law firm called Bowman's. Took a break from the law for a while, went to study in England, African philosophy and music, and somehow like three or so years ago, with always kind of been passionate about the budding, and at that time even the illegal space, a friend and I, a ton from Legalities, we considered looking at this space from a legal perspective. It was just subsequent to the 2018 landmark judgment, which I'm sure we'll always, in all these conversations, we're looking back to that judgment. So I'm sure we'll look into it a little bit more in this one, and just kind of started very organically consulting to clients on a range of questions and things that they were looking to achieve. Obviously, most people, master growers such as yourselves, who'd been enthusiasts and cannabis people their whole lives, and now what to do. And so I guess I formed a part of that whole big kind of movement, more from the legal side, never having really been a master grower myself, but always been passionate about it. And I guess here we are a few years later, doing this type of work with wonderful people such as yourselves, and just kind of looking to get more and more entrenched in whatever capacity possible. So I consult in the space. I consult to clients of certain legal advisories such as Legalities and others now. I do some work on my own. And yeah, I mean, cannabis is the space we're all very passionate about, what it represents to us in our country and our communities. And that's
recently did a cool book with Marlene Tennyson, that framework for private cannabis clubs, a manual.
Here it is.
Yeah. Congratulations on that, man.
You guys are the best, man. I love that reaction. Yeah, thanks, man. It was a lot of hard work. I was lucky, Marlene I was always kind of consulting to her, assisting on the legal aspects of her book. So like reviewing it, and she, and so working for her. And then towards the end, it's so much of what goes into this work, as you guys know, is of a legal nature, even though the space is so gray at the moment, that she actually invited me to be a co-author, which was very lekker. And yeah, we published this manual about a month or a bit more ago. It's available on Marlene's Cradlestone Quality Solutions on her website. And it's very exciting. I mean, I can tell you a bit about what we try to do with the manual if you're interested.
Yeah. Please elaborate.
Thanks, man. So I mean, like we make it very clear, like everywhere. I can even just read from the back a summary, like, the manual does not attempt to establish any legal or other prescriptive norms or industry standards in relation to private or social cannabis clubs. And we believe in the legitimacy and operational adequacy of many private cannabis clubs that for any reason don't conform to our recommendations. So I'll start with that disclaimer just to say that, we've put together this manual for the setup, so the establishment and the management of cannabis clubs. It's very firmly grounded in what we think is a relatively prudent reading of the 2018, the Prince Privacy judgment on the decriminalization case. But having said that, we're not trying to establish a norm that anyone who's trying to set up a cannabis club must conform to. It's there to empower people. So for example, just this morning even, I had a call from a lead from a potential client who wants to start a cannabis club or is thinking of it. And he doesn't know how to do it. He doesn't know what model he should adopt. He doesn't really understand it. Yeah, so instead of saying to him, look, man, I can consult to you for a number of hours. It's going to cost you a lot more money than the book does to help you build and own your own business. You know, this is designed precisely to empower people like you. In my view, it costs a lot less than consulting a lawyer or some other consultant to build you your own kind of model. And, you know, go through it, their notes, their note pages to make notes, take it apart, you know, highlight it, and build your own model and build your own kind of cannabis club, and or decide that you don't want to, but the manual's there to help you decide whether this in fact is the space for you to operate in, and to hopefully give you kind of guidelines from a legal and then systems perspective of how to do so, with making recommendations, not saying necessarily this is how you must do it or this is the only way to do it, but this is how you might do it, and how a court, if the cops rocked up and wanted to put you in prison, and you ended up in a high court and you had to try to justify your model, we think a judge might reasonably agree with these types of models. And so that's really what the purpose of the manual is, and to assist really those I mean, it's hard to say there's any way which the CannaClub's operations can be improved. I mean, such an amazing operation, but even already existing clubs that might in a certain aspect of their operations feel like they need some to buff up certain SOPs or whatever the case is, this you can look into it and there'll be something on that for you. So kind of like to assist you to establish and maybe improve or enhance your operations.
Yeah, it's critical information that's really hard to find. Points. First off, I just want to start off with the current status of the current legal status of cannabis in South Africa at the moment. We had the Concord ruling in 2018, and what would you say is our kind of rights at the moment? Where does the line get drawn?
So I think the way I've started to kind of, from an abstract perspective, general perspective, start to consider our era in cannabis is we're at the final decay of the Prohibitionist era, right? And I still think, unfortunately, you know, of course, we have the medicinal sector, which if you invest heavily and you get your GAP and GMP licensed facilities from SAHPRA in terms of the Medicines Act, and it's very costly, etc., you can operate in that space. We now have the industrial sector, as you guys know. So if you're dealing with low THC cannabis, you can now get permits from the Department of Agriculture, Land Reform and Rural Development to operate in that space. So for industrial and agricultural purposes. But by and large, as we know, the drugs legislation, the Drugs Act is still in force. So even though personal and private possession, use and consumption is now no longer illegal, it's still illegal and prohibited to deal, which has such a massive and archaic and even racist underpinnings from the apartheid era. It's this piece of legislation called the Drugs Act, definitely in relation to cannabis. So I would say, you know, from a general perspective, we're in the era of the final or the end or the final decay of the Prohibitionist era. I mean, you know, I don't know if you guys want to chat about the bill, if it's a separate question, but that's currently in the works.
Yeah, no, we do. We definitely want to ask your opinion on it. We saw that the complementary medicines regulation was declared unlawful, and it's a lot of fancy words and stuff. So we were hoping that you could give us a bit of clarity on what exactly is going on there.
Case against SAHPRA recently declaring the supplementary.
Is that the one you're talking about?
Right, so we can talk about when we're talking about the end of the Prohibitionist era. I mean, So the judgment that we just received, it is exciting news, I agree, out of the SCA last week, was in relation to the medicinal sector and complementary medicines as medicines. The bill itself, the Cannabis for Private Purposes bill, is the piece of legislation that the Concord ordered Parliament basically to make in order to give effect to the rights to now personally and privately cultivate, possess, use, and consume. So we can talk about, I think we should talk about them separately, and I'll take it from, I'll take my lead from you guys.
Absolutely. So according to that privacy bill, after that, we've seen like a massive surge of clubs opening up and like farmers getting a bit more involved in the commercial sector. Like they can now get licenses from SAHPRA to grow for export and all that. What opportunities are currently available for the farmers in South Africa in the cannabis space?
So I think so. One of the obvious ones, I mean, this is us talking to each other here. You guys run one of the most awesome cannabis clubs in the country. I mean, that's the one obvious space to be operating in, right? So for guys who've been cultivating cannabis their whole lives illegally and now don't have millions of rands to invest in a SAHPRA certified medicinal plant, basically. When I mean plants, I mean investment facilities, etc.
Facilities and equipment, all that, yeah.
Which is going to cost you into the millions, not for the application fees itself, but for SAHPRA, in order to get that license, you have to show to them within your application, in fact, that you actually have these facilities in the ground. It's not a business model that you will one day, once you raise enough money, do X, Y, and Z. You need to, in your application, actually show them that you have this in place. And, by all accounts, you're talking about multi-million rand plants.
In the latest video, we discussed that with Carl from NeoFarm. They've also got an export facility there. And he discussed with us, the license is only like 28,000 Rand. But you need all these plans in place for a facility to meet those certain standards, security measures and all that. And that adds up to...
That's where the cost lies.
Yeah, that's where the costs come in.
Exactly.
So as you say, it's not really accessible to everyone at the moment, unless you have like massive capital available. Like the legislation around that, do you think after like the most recent discussion that the president had with us at the SONA, at the State of the Nations, do you think it's heading in a direction where it will become more accessible, like for the clubs?
We will review the policy and regulatory framework for a whole number of other processes, but more importantly, which will come as sweet news for our people in the Eastern Cape and KwaZulu-Natal, for industrial hemp and cannabis to realize huge potential for investment and job creation. Now, this natural product, which our people have been farming with and harvesting for a number of purposes, is now going to be industrialized. And no longer just being resorted to the smoke process.
Yeah, so I think, bear in mind, I think there's one other space that maybe your listeners who might be growers of other things, for example, who could pivot, for example, into the medicinal space if they have quite, there's a famous kind of like the Felbridges, the Zettlers, they were strawberry farmers, and they could quite easily kind of, as I understand, convert their operations into a medicinal grade cannabis facility. So let's not forget about that for a moment. However, for 90% of South Africans, that's just not the case and not possible. We're thinking of the million cannabis cultivating families in the Eastern Cape and the Dagga Belt. I mean, how are these guys going to participate? How are the Rastas in the Western Cape around? So the Cannabis Club for growers, for people who already know how to grow, is the obvious thing to do right now. As we keep on mentioning, it is a gray area, but there's two things to mention there. There's this bill that's coming out. I'll get to Bertie to the SONA address in a second, which the state law advisor, Mr. Sadel, has mentioned in the portfolio committee meetings that he doesn't want, he thinks that cannabis, it's positive and less positive for clubs, the bill, because the state law advisor has said he doesn't specifically want to regulate clubs through this bill, right? He wants to generally regulate private consumption of cannabis, legal and lawful private consumption of cannabis by consenting adults in their personal capacity. He doesn't specifically want to regulate cannabis under this bill. However, it's going to inevitably happen because it is a piece of legislation that have words in English that directly apply to the things that we are doing as clubs. So we have to wait and see. But so following on from the SONA address, to get back to Betsy's question, the president said he was talking specifically in the context of the hemp, of the industrial agriculture as a low-hanging fruit, right? But and we'll talk about that because it is a low-hanging fruit. In the context of the cannabis industry, you're talking about low THC products. You don't have all the political kind of and ethical kind of to and fro in parliament around the consumption of whether you think it's a drug and whether you think they're harmful. You're talking about products that are going to be going to be used in the industrial sector in the millions of like green solutions, whether it's the fibers or the herds for hempcrete and biofuels. It has really the potential to remediate our soil and really build a strong economy, assuming that it can be accessible to lots of South Africans. By all accounts, if you look at the guidelines that the department, it's DELRAD, the Department for Agriculture, Land Reform and Rural Development. Your listeners can just go to that website and find the Directorate for Plant Production and find those hemp guidelines there. I'll send you a link if you guys want to for your listeners.
Yes, that'll be great.
When you compare those so-called barriers to entry, the regulatory red tape in those guidelines and the regulations are obviously far, far less stringent than the medicinal sector. You're not looking to create medicines that are promising to cure diseases and whatnot. You're using the stalks to do a number of industrial applications, which can mention hundreds. Hempcrete and concrete is a massive one. The whole textile and industry is a massive one. The rope industry, the canvas industry, it's endless. The biofuels, and so the legal barriers to entry are far less stringent for that reason, because they're not going to be consumed by human beings. And I also do believe that if you have a piece of land where you're growing and you can produce, you need tonnage. That's the big thing when it comes to hemp. We're not targeting grams of beautiful flower, right, which you can sell for a lot of money. You need to throw hundreds of seeds into the ground. The nice thing about it is you can just throw them, male or female, it doesn't matter. You're targeting the plants and the stalks and fibers, but you do then need to produce tonnages in order to be profitable. So that is the challenge on
so
on
it's
this side.
directed more towards hemp, but that doesn't so much. Will that have any implication like on the cannabis, the recreational cannabis growers?
So that specifically, no. But at the same time, subsequent to the SONA address, in the portfolio committee meetings, that the portfolio committee of the Department of Justice and Correctional Services, now that portfolio committee is responsible for drafting the bill. And they recently, in early March, they basically have proposed a number of new things. They proposed this new commercialization clause. Okay. And in that clause, so essentially to commercialize the recreational sector, right? I mean, we can talk about, I don't personally like the word recreational. I think it should be called adult use, but we know what we're talking about here. So in this proposed amendment to the bill, so bear in mind, it's a proposed amendment to a bill. The bill itself is not law yet. So these amendments have to be accepted to the bill, and then the bill then has to go further through the parliamentary process, including the National Council of Provinces, etc., and to be signed by the president. But to get back to the actual proposal, it's not the commercial industry for recreational cannabis is hereby authorized. It says those words, but it's subject to the enactment of further legislation, right, by the relevant department.
Just a proposal.
To that effect. So it's a proposed insertion to the bill, which says the recreational commercial cannabis sector is authorized, sub clause 2, this proposed clause, that such legislation must deal with, but it doesn't say that this is it's not the legislation itself, right? So that proposed clause as an amendment to the bill is being considered now. If your listeners are interested in submitting submissions on those proposals, they can do so to the portfolio committee by the 13th of May. I can also separately that invite.
Yes, please.
To do so. And so that's been one of the proposed amendments to the bill, okay? And in addition to other ones are very important as well, because as soon as the bill came out, you know, Russ Gareth Prince and the whole community really came out in strong criticism that the bill would be challenged immediately upon enactment. It's so unconstitutional. The penalties are still harsh. They still oppress and marginalize cannabis cultivating and consuming communities. The penalties, you know, there's still 15-year imprisonment penalties for things that at the moment, even during prohibition, you probably wouldn't be saddled with in court. So in addition to that proposed commercialization clause, the Portfolio Committee is listening to us, and they've lessened those sentences. There's class A, B, C, and D of offenses in terms of the bill. There's still those classes A, B, C, and D, but they've reduced the maximum sentences in each by around half. And they've also increased some of the allowed or prescribed limits for in certain categories for people to possess and consume. And then the final thing, they've done a few things, but you know, I think you can summarize them in 3 general categories: that commercialization proposed clause, the lessening of the harshness of penalties, and then also they've included a clause for people to be able to, on a doctor's prescription, self-medicate, right? So not necessarily get access to registered medicines, and for those in palliative care towards the end of their lives and others can actually, and this I think will actually have an impact on cannabis clubs, because up to now we are, I think, using cannabis clubs for people who want to use cannabis, we say the word recreationally, but not necessarily with the direct kind of aim of assisting people with medical conditions. And I think this clause might have, subject to no further interpretation and whatever, might have something to kind of assist us in that regard, to help people in our communities through clubs. But we have to wait and see.
Okay.
Yeah, and then we can get to like this whole thing that happened now with SAHPRA over the last couple of weeks and whatnot, where the medicines, what is it called, complementary medicines regulations, that was declared unlawful. And what does that mean for us?
How's it, Roy? I just won a major court case, a Supreme Court of Appeal case. I headed up this thing. Basically, our SAHPRA, the medicines regulator, was attempting to publish published regulations that were going to shut down the entire natural health product industry by regulating them as pharmaceuticals and making them unavailable to the public. So things like your vitamin D, your vitamin C, and all these things that are absolutely essential for the immune system and for people to remain healthy and strong throughout this whole COVID pandemic, were being targeted essentially by Big Pharma to be taken away from the public as a choice by making them into pharmaceutical products. So we launched an application and we won the case, where the Supreme Court of Appeal has agreed with the High Court matter, which we won, that essentially these substances are not medicines and therefore cannot be regulated as drugs. So it's basically taken out of the clutches of Big Pharma, who wanted to expropriate the whole natural product industry and stifle it.
It is massive news for the complementary medicine sector in general. Now, what is a complementary medicines and health supplement sector in general, right? So the Medicines and Related Substances Act, 101 of 1965, the Medicines Act, right? It regulates our medicines industry. It also therefore regulates our medicinal cannabis industry, because it's just another medicinal, cannabis was scheduled in terms of, basically any substances scheduled in terms of the Medicines Act. So there's schedules 1 to 8 at the back of the Medicines Act. Schedule 1, these substances; Schedule 2, these substances, all the way to 8. Cannabis is no longer a scheduled substance, but THC and CBD is, right? And the Medicines Act regulates medicines and scheduled substances. And medicines ordinarily include scheduled substances, right? Yeah. But not always. So that's a brief overview of what the Medicines Act does. And it does so via licensing regimes, as we've been talking about. If you want to grow medicinal cannabis, you need to get the license, you need to register your medicinal products, you need to comply with labeling regulations, you need to comply with a host of things, right? But primarily those things. And so complementary medicines, the Act itself defines what a medicine is, okay? And in general, it's something which is used or is claimed to be useful for the prevention, diagnosis, etc. of diseases and for the restoration of the physical state. So that's generally what the definition of a medicine is, okay? Now that's a piece of legislation. In that piece of legislation, in the Medicines Act, as with many other regulated industries and their primary piece of legislation, the minister of that sector, in this case health, is empowered to promulgate, to publish, to make regulations, to flesh out exactly how that legislation is to be applied, right?
Okay.
So it's very important. The legislation is made by our democratically elected government. We vote people in primarily to make the laws that govern us. The minister then assists Parliament in its duties by really implementing the primary legislation through regulations, which gives the industry a much more detailed understanding of actually what Parliament was trying to achieve, okay? And so in that Medicines Act, if you look at section 35, I think, it'll say the minister is hereby empowered to publish regulations on, and then it lists like 20 subjects, right? In general, it's there, the minister is there to assist Parliament to make the purposes or the objects of the medicines regulations a reality through regulations. Okay, so while the minister has that power, the Minister of Health, it can only use, he or she can only use the powers granted in terms of that empowering piece of legislation. However, in 2017, the Minister of Health published what they call the general regulations in terms of the Medicines Act. They call them general because it deals with all of those things that the minister was empowered to do in terms of regulation, if not all, pretty much most. And one of the things the minister did in 2017 with those regulations was include a subcategory of medicine called complementary medicines, right? Okay. And in that definition of complementary medicines, it went far broader than what the definition of medicine that we've just discussed in the Act actually contained. So they included a whole new category of medicine, which went broader. How did it go broader? It didn't just say, you know, a complementary medicine is a medicine which you know, kind of is it fits into the definition of medicine in the Act. It said it included those things we discussed, so the prevention, diagnosis, mitigation, etc. Of disease, to summarize it, as it's longer and more detailed than that. But they also said any substance that complements or maintains basically our system, our bodies, right?
Like
so complements,
B, C, all those things.
Say again?
Like vitamins and all those kind of things.
Exactly. So health supplements are a form of complementary medicines. And for example, yeah, so it didn't just say, you know, complementary medicines are something that conforms with the definition of medicine in the Act. It said it basically it mirrored that definition and went broader to say it includes things that kind of just complement or enhance or maintain your health, to summarize, right? Now, since then, everyone in the industry has been saying, in the medicines industry in general, that is ultra vires, that is beyond the power that the minister has. The minister can regulate medicines, can't regulate medicines plus things that are not medicines. Right? You understand? So essentially what the minister has done is create a whole new category of medicines, which is far more broad than orthodox therapeutic medicines, and subjected those things, complementary medicines, including health supplements, etc., to the same very strict, very expensive regulatory regimes that apply to you know, prescriptive drugs. So the GMP licenses, the registration of the medicines, all the hectic labeling and package information and other requirements, the advertising requirements, the sampling, the bonusing requirements, right? When tons of these products, don't contain any substance that is scheduled in terms of the Medicines Act at the back of the Act, right? And obviously for that reason are not dangerous, don't provide any harm. A lot of these things are herbal things, which of course pose no risk to anyone, irrespective of the cannabis world or not, which we'll talk about the impacts in the cannabis world of this judgment. And so basically in the High Court, the Alliance of Natural Health Products, headed up by Anthony Rees, which is he's really been the soldier behind this change, this regulatory change. They won in the High Court. And then the Minister of Health and SAHPRA came together, appealed the High Court judgment in the Supreme Court of Appeal and lost again.
Oh, wow.
And basically, there have been there are other intricacies around cross-appealing and whatnot, but suffice it to say that the High Court ruling was upheld. And essentially, I can read you the part of the order that is important here. I've actually got the judgment here in front of me. I'm actually trying to write a little piece on it. I'll send it to you once I'm done. But so this is basically the order of the court. The general regulations promulgated in 2017 under notice XYZ are declared unlawful to the extent that they apply to complementary medicines and health supplements that are not medicines or scheduled substance as defined in Section 1 of the Medicines Act, right? So that's exactly what we've discussed. So, however, it's important. Say again?
Cannabis is not a scheduled medicine, right? So technically it shouldn't. Well, I don't want to jump ahead with your explanation.
So yeah, so that's what they've ruled. Bear in mind, they also said that this declaration has been suspended for a year. Okay, so essentially, we'll go into cannabis now, but the effect in general to the medicines, the complementary medicines sector in general, is that these regulations do not apply to complementary medicines that do not also satisfy the definition of a medicine, right? So therefore, those things.
No.
Yeah.
No, sorry. So in layman terms, basically, SAHPRA wanted to take complementary medicines like normal herbs, what can we say, like pucha and all those things, wanted to monopolize it so that if you want to cultivate it, you had to comply to all these regulations and all that. Is that basically?
Yeah, that's fair. I mean, I think monopolizing is a strong word. I mean, I think I'll leave that to you to decide. But that's the way you see it. But in essence, it's quite an accurate way of. Sorry, I'm just declining a call. Yeah, I mean, essentially, there's a whole very important industry of health supplements, vitamins, etc., that have to comply with the same thing that hectic Schedule 6 drugs have to, right? And this is essentially what is the victory here. It's no longer going forward, because what the order now says is that the Minister of Health, working with SAHPRA, but it's the Minister of Health that must now actually separately regulate complementary medicines not subject to the same kind of stringent requirements as regular kind of prescription drugs and whatnot. How does this, to get to the tachlis here, it's a strange word that Jewish people use, how does this affect the cannabis sector, right? So this is the question now. With all of that in mind, sorry again for the ramble, how do we apply this? How is this actually useful for us? Well, it's really useful primarily in the context of the CBD sector, because THC, right? Cannabis is no longer a scheduled substance, as Harry, you rightly mentioned. That's great. But THC is a Schedule 6 substance, other than limited exceptions. Now we know what those exceptions are. The hemp sector, where it's low THC and applied for non-human consumption purposes. So the industrial sector, low THC, right? When we're persons acting acting in terms of the privacy judgment and accessing our rights, such as in the manner that the club does. And then it's got quite another technical, unimportant exception, basically when in cannabis seeds, when intended for human ingestion, but contain less than 0.001% THC. So THC is a Schedule 6 substance, okay? CBD is a Schedule 4 substance. However, as you know, we've seen our CBD market kind of burgeoning in the last few years. Why? Because there's an exception to when CBD is not a Schedule 4 substance. It is a Schedule 0 substance, which can be purchased from any retailer, right, when certain thresholds have been met. When its pack sizes are a maximum of 600 milligrams, when it's got a maximum of 20 milligram per day dosage, and some other, and they are only intended for general bodily enhancements. So low risk health claims. So as a complementary medicine, right? So it's CBD is a Schedule 4 substance unless it's a CBD product that meets those kind of thresholds, and then it can be sold as a Schedule 0 product. A Schedule 0 product can be sold like a grandpa in a corner cafe. It can be sold from anywhere online. So where does the judgment really assist, or primarily hopefully assist going forward? It will be cannabis products, right, which are essentially Schedule 0 and are not heavily scheduled. Because if you're talking about THC, right, for example, the use or the application of THC that is not in those 3 exceptions that I mentioned, you're then talking about, which is most of the time, right? You're talking about a Schedule 6 substance. If you're talking about the production of a Schedule 6 substance, you then are subject to the licensing framework, etc. As I said, the Medicines Act regulates medicines and scheduled substances. Scheduled substances are most often contained in medicines. So the way the value chain ordinarily works is that you want to produce, let's say in this case, THC, right? You get a license to produce medicinal grade cannabis. With that license, you are then able to manufacture medicines, right, that contain that substance. Then in order to supply it at large in the industry, you need to get that product itself that you have now manufactured in terms of a license registered with SAHPRA in order to ensure the safety and efficacy of that medicine. And then it gets sold on the market as a Schedule 6 drug on prescription by your doctor, right? So do you see what I'm saying? It's only where a substance is a Schedule 0 substance. So for example, here, CBD in these specific preparations, that this judgment will really assist, because it's in that complementary medicine kind of realm. It's not in the regular kind of therapeutic drug realm with highly scheduled Schedule 6, for example, substances that occur in like regular kind of antibiotic drugs and whatever the case is, whatever. Schedule 6, it's from Schedule 0 to 8, 6 is relatively high up, right? You need your licenses to produce medicines that contain them. Not the case going forward potentially with CBD because of this judgment. The Supreme Court of Appeal has said, no, you cannot treat complementary medicines which merely assist the body to in its kind of ordinary forms, vitamins, health supplements, CBD products that assist general anxiety, general sleep, or kind of stuff, not specific kind of diseases. You cannot regulate that as a medicine. It is not a medicine. Go back to the drawing board, Mr. Minister of Health, and now make something that makes sense and doesn't create too many barriers to entry, coming back to Bertie's use of the word monopoly, which does make sense. Go and regulate them in a way that is fair, makes sense, and actually can assist our population to benefit from all these wonderful kind of health supplements, which are not hectic drugs.
Yes, man's a master.
Thanks, guys.
And SAHPRA's role, just generally, what is SAHPRA's role?
So it's SAHPRA's role. So it's a good question, Haze, because we think that it's a very straightforward one, but it's not so straightforward, because SAHPRA, it's the Department of Health and the minister, like I said, make regulations to give force and effect on the ground to the Medicines Act. SAHPRA is there to regulate the medicinal industry, but how is that now different from the department, from the minister, from the ministerial duties? Yeah. It's different really because they are the ones responsible for monitoring, issuing, rejecting, granting licenses, for ensuring that products. So like I said, if you want to make, if one day, let's say the CannaClub pivots into the medicinal industry, now you're making wonderful cannabis containing products, you can't just go and sell them. You have to submit a docket, which is a very hectic process basically, to SAHPRA to register that drug, and now you can sell it freely to pharmacies, dispensaries, etc., for example. So SAHPRA makes sure and enforces that the act is basically interpreted and applied properly by the industry at large. It does that by way of its licenses, by way of ensuring that products are safe and effective and registerable. It does that by way of ensuring that the labeling, the advertising is a big one. Lots of people out there have kind of hocus pocus claims to the things that they provide. SAHPRA that ensure that advertising is done responsibly and that type of thing. Therefore, also to issue guidelines to give effect to all those things. How does one get a license? How does one register things? How does one comply with the labeling requirements, etc., of medicines? And so that's what SAHPRA essentially, it's a South African Health Products Regulatory Authority, and so it regulates health products. We presume that with these new regulations,
the Minister of Health will assist the Parliament in creating the regulations, and then SAHPRA will basically enforce and be the the guys on the field making sure that everything's working according to the plan.
Exactly. The minister is not interested, and it doesn't with ensuring that licenses are granted. It doesn't grant licenses. He or she, you know, that body, that office doesn't grant the licenses, doesn't make sure things are. So that's exactly it. And again, really, like as a summary to this whole discussion on this judgment, it's critical, I think, for you guys also to know, and your listeners to know, legislation. When it comes to, we've got our legal system works as follows. We've got our constitution. It is our Bible. It is our founding document. It gives, or actually I like to think of it from the ground up. Our constitution is our roots. It's everything. Everything is given force and effect through the constitution. So any law or regulation that is inconsistent with our constitution is not law, and it will be declared invalid by a challenging court, right? Then legislation is the next kind of level of, the constitution is still legislation, but it's the primary and the basic and the supreme law. Anything in conflict with it is invalid. Then you have legislation, which is the democratically elected will of the people making laws for us, right? Then you have regulations, right? Which the regulation, in the same way that laws need to be consistent with the constitution, the regulations need to be consistent with the powers granted in terms of the legislation. Right, so the minister can never pass a regulation that is in excess of the powers granted to him or her, or it, if it's an office, right, in terms of the empowering provision in the legislation. The minister may do this. You have to read the legislation to see what the minister may do. In this case, the minister may not. It didn't say the minister may create a whole new sector of medicines or subcategory that is subject to the same high stringent requirements as prescription drugs.
What impact is this new ruling going to have on SAHPRA, and with this whole thing that now happened with the complementary medicines? What's that going to impact on SAHPRA and their regulations on GMP facilities and stuff like that?
So I think, as we just said, like where this ruling will have the most, I think, primary impact in the cannabis sphere will be in CBD products, and going forward. We doubt that people who are creating CBD products will need to get licenses, GMP stamped certified licenses, right, in terms of the act. However, it's important to note, yes, that the SCA, the judge in this case, Van der Merwe, said that the minister, it's not SAHPRA, remember, who makes the regulations, it's the minister who must go back to the drawing board and properly regulate these things. It's not that anyone can now do what they want with complementary medicines and make whatever claim that they want. They still must be regulated, but much more likely. So Haze, yeah, I think what this does is, firstly, it's going to force SAHPRA to go back to the minister to go back to the drawing board and separately regulate complementary medicines, not as a medicine, maybe something more related to foodstuffs legislation, which the judge did actually make mention of in the judgment. And whether it will be SAHPRA or not, because the minister will make these regulations, the minister will say SAHPRA is defined as the authority, and SAHPRA will also regulate. They might also decide that another department of government is responsible for the regulation of these things. So it's a very interesting power play that's happening between industry right now and SAHPRA. And what we're seeing more of, I think, is that the courts are really willing. It's not even willing. The courts see things, I think, quite clearly. And you take a challenge to a court, assuming they're independent, which in this case it seems was the case, they make a ruling there and then, which then has big impacts on the powers that our regulatory authorities have. So we're starting to see that SAHPRA is not just this automatic kind of body that will regulate all the medicinal cannabis sector. This is a perfect example of that. I mean,
human rights with the constitution, as you said, that's where it all starts.
Exactly, and that affects human rights. It affects our access to healthcare. There's a whole bunch, exactly. And I think that's also, I think, interestingly, I think lawyers in the sector have been making this comment or criticism or argument for the last few years. I mean, I know I've read others also that are presently doing it now. SAHPRA does not, the minister and SAHPRA does not, in terms of the Medicines Act, right, the empowering legislation, have the power, the mandate. There's an argument, I think a strong argument that can be made, that SAHPRA actually has no place regulating the cultivation of cannabis at all, right? If you look at the way that the Medicines Act defines the supply chain, it starts in terms of the Medicines Act, if you want to, with the licensing process, with the manufacturing stage. You've got manufacturing, distribution, wholesale, import, export.
Department of Trade and Industry, bro.
Well, Department of Agri, maybe, and DTI. But the point I'm making is that there's a strong argument to the SAHPRA just came in 2017 and said, we're taking control of the cultivation of medicinal grade cannabis, right? It didn't do that, I don't think, with paying enough attention to its powers in terms of the Medicines Act. I'm not saying 100% have no role to play with the cultivation of cannabis. Of course, if you want to be supplying cannabis into the medicinal sector, starting at the manufacturing, obtaining raw materials. If you look at the definition of manufacture in the Act and then in the regulations, you'll see that it doesn't say the agricultural production of scheduled substances. The word agriculture, the word cultivation is absolutely absent from any of our medicines laws and regulations. So, but SAHPRA took it upon itself. I'm not saying in bad faith, I think in good faith, but the point is potentially without paying attention or disagreeing with this argument that we're all making is that in fact SAHPRA should potentially only be regulating the medicinal cannabis sector from the manufacturing stage, which if you look at some of the wording deployed in the legislation and regulations might only begin at the purchasing of raw materials, right? And then production in a lab as other drugs are manufactured with that process, not the cultivation of a raw material. And so if I'm saying to your listeners, to anyone out there, like if anyone has the appetite and the Haze and the cash to take SAHPRA to, I think SAHPRA one way or another in the coming years will be taken to task. Just following on from this conversation about the shrinking potentially powers of SAHPRA in the cannabis sector, and say, look, guys, you actually don't have the power to regulate medicinal cannabis whatsoever. It's an agricultural good. Yes, once the THC has been extracted and then it goes into the medicinal supply chain, yes, then you need GMPs, it needs to be X, Y, and Z. So I think someone's going to make this challenge at some point. And when they do, I believe that it will open, that's really when the cannabis sector will open up to so many, it will be further opened up to those who are producing quality cannabis, but not at these ridiculous kind of GMP and even GAP levels that SAHPRA requires. And, we can dream that at some point in the near future, that challenge will be forthcoming. But for now, we're making, small steps. We see it in the case of legislation, in the case of the bill, the parliament, it's doing its job, it's listening to us, it's too slow, but it's actually happening. But also we mustn't forget that our courts are still very independent and are making, they're listening to cases brought forth to them by industry players and ruling independently. So including hopefully in the Haze Club case, which we haven't discussed, which was going to make binding precedents even more directly applicable to the CannaClub and other private social cannabis clubs. And that we hope will be sometime this year. We've been waiting for over a year and a half. This can has been kicked down the road by the high courts and by the minister of police. And so we wait also for that very important judicial precedent to give us all guidance on how cannabis clubs might.
So that's a big one at the moment as well for the cannabis community, is the Haze Club case. That's going to be a deciding factor on the how can I say the way forward.
It is, Bertie. It is going to be huge, definitely. But we must also bear in mind that the Haze Club, the model of the Haze Club is the Haze Club's model. Through our relationship, we've learned, for example, that the CannaClub has a very different model of cannabis club to the Haze Club. Now, the judge is not being asked to say that all cannabis clubs, however they are modeled, are legal. They're saying these guys, the director of the Haze Club, has been charged with dealing. The response is no, well, it's legal because look at what we do is we're actually just assisting members of the public to access their privacy cannabis rights as per the judgment. But they do it in this way. The CannaClub will do it in this way. And so it will be hopefully we're hoping for a ruling that basically says that one can access their cannabis rights by the cultivation on their behalf of another, for something like that. If a ruling like that will affect the whole sector or the whole cannabis club space, right? But if they just say, well, this model itself on its own very specific terms is in line with the privacy judgment, then we have to nitpick. Then you have to come back and talk to me and we have to say, Brett, is that exactly what the courts, how does it affect the CannaClub as a model that has kind of a beautiful Stockfell and Growers co-op, not just individuals coming and concluding very individual kind of agreements with the club to access their own individual rights, again, individually, so we'll have to see it. I'm not undermining. It's going to be a huge judgment, and there'll be follow-ups from that judgment, and it might go all the way to the Constitutional Court, and who knows what they will hold, and who knows what the legislative, what the legal landscape will look like by then. But it's happening. But we must pay very close attention and just keep our fingers on the pulse.
Essentially, their model is like being tested in court right now. Do you think all the models should also be tested so that we, tested and tried, and so we know what we can and can't do?
Well, hopefully not.
Do you think they're going to be tested? I don't know. I'm just throwing it out there.
So tested. When you say tested, Haze, I guess you mean in a court of law. What do you say about tested?
Court of law, yeah.
I mean, we want and we don't want that, right? We don't want it's gone through enough cuck, you know what I mean? It's not like leave us alone kind of thing, right? So that's why we have to kind of be grateful and see almost as the Haze Club is almost being soldiers in this regard, because they have taken this case on. They'll have to incur the heavy, I don't know what their relationship with their lawyers are, if they're doing it pro bono, who knows? But the point is, there's a lot at stake here. There's people's freedom at stake and cash. And so do we want to? I think it's a fantastic exercise, like intellectual exercise, to test in our own capacities. This is this club, this is that club, and how does it fit within the privacy judgment? Because to answer your question, the only legal precedent we have for cannabis clubs right now is the privacy judgment, is the 2018 Prince judgment. So going through that exercise in our minds is what I, as a legal practitioner, as a legal advisor, do whenever a client comes to me. That's precisely what I'm doing. I'm testing the model against my interpretation of the Prince judgment. So we are testing. It depends who we are and how we are, but I don't think we want to see all these cases in court with people being locked up. We just want to be able to access our rights and our human rights, ultimately, as Bertie keeps on referring to very rightly, to privacy, to associate, to bodily, to freedom of movement, to all of these things, to pursue the life that we want, that doesn't harm anyone else. I don't know if that answers your question.
No, it definitely does.
I think they're becoming more and more aware of the clubs. I think it's more a case of, as you said, in the beginning, SAHPRA didn't take the whole picture into consideration, because now at the moment you've got this heavy entry barrier for the people that they can cultivate, and you can get your license for 28K, but still where are the clubs and all that? That's the majority of the movement where we can create a lot of jobs and so on, So I think now for the first time with the Haze Club, they are taking a look at the clubs, and now they can take that into consideration to create more of a legal space for that.
Exactly. And so we want, you're asking me the questions on this call, but here's a question for you. Would you guys as cannabis club operators, would you like to see the Cannabis for Private Purposes bill have a clause in it which says cannabis clubs are allowed, and here's a whole bunch of like restrictions and regulatory requirements? You need to get licenses. They might be cheap, who knows?
No, we'd love it to have some kind of regulatory guidelines to how we're supposed to go about it. Yeah, 100%. Of
course you would, yeah.
100%.
And then we also have to then always consider how the guys in the Eastern Cape are going to like participate in this whole thing, right? How the previously disadvantaged,
rural communities in this thing.
Rural communities. How are we going to like rope everyone inclusively into this thing? I think my personal opinion is, when it comes to the full I don't know about the interim private cannabis club space and how they'd be regulated. We need to bring them in. I think we have obligations, as we've had many discussions before between us. We need to work on ways to assist guys to create clubs and form part of a bigger kind of family of clubs. And we're talking about that, and I think something's going to happen. But on a more long-term and sustained view, I think the ultimate kind of ideal position would be to have as absolutely little regulation around what the guys in the former Transkei are doing, right? Just basically make them legal. Just flip the switch and say what you're doing is no longer illegal, and tax it. Yes, if you want to produce a medicine that's going to claim to cure cancer, or even to have anything to do with relating to any, hectic, regular kind of therapeutic malady or whatever the case is, yes, you got to sell it into a hub. That then needs to be okayed from a medicinal perspective, and on you go. And that way we can channel and target the whole plant. We can target the flowers for this sector. We can target the stalks and the fibers and the seed for that sector. We can target the seeds for the whole grain and health supplement sector. We can target the leaves in that way, right? And we can actually create a sector whereby guys, wherever they are, right, surely, I mean, you're not going to want to plant, going to throw 20,000 seeds in the ground and you don't know whether they're feminine or masculine, and then try apply that successfully, you know, in a kind of context like your cannabis club, because obviously people want feminized, high grade stuff. But I'm saying in general, as a general proposition, people must be free to grow what they want. They must be clever enough and have the initiative to target what they think is going to yield profits. And then when it comes to that specific industry from a manufacturing perspective, if it's a medicine, it must go off in that direction, be regulated like that. If it's clothing, it must go off in that direction and be regulated like that. If it's food, it must go off in that direction. So regulate the end use. And that's hopefully what, but from an agricultural, from a cultivating perspective, I don't think we should regulate it the same way as we regulate a tomato. I don't see a reason why.
Otherwise, we're just hindering like job creation and all these opportunities. We're just blocking our country from all these massive opportunities.
100%.
Exactly.
And what can we expect, in your opinion, over the next 2 years to change or to come? What's in the pipelines in the legal world?
So I think maybe just to summarize almost the discussion that we've had. So you're going to see a whole new regulatory regime within the next year relating to complementary medicines. We're really going to see hopefully our CBD industry, and maybe not just CBD, because with CBG, CBNs, the whole host of medicinal valuable cannabinoids and whatnot that are not necessarily Schedule 6 things like THC will be regulated more likely. So we'll see hopefully something definitely in that regard. We've got the Haze Club in the pipelines. Hopefully we'll have something positive from them. Good luck to those guys. We've got the bill in Parliament now. It's being considered. I think my personal view is that the bill itself will maybe be finalized and enacted in no less, but maybe around in a year from now, with hopefully something to say about the subsequent commercial recreational adult use sector, right? Do I think that in 2 years from now we will have a fully licensed legal framework for adult use cannabis? I think it will be around then. I think, like, if we're being a bit prudent, I don't know, something like 2 to 3 years. It takes time. You know, we've seen this, just the bill, the Cannabis for Private Purposes bill, which is just to regulate people's private use of cannabis, not a full industry, right? Not a sector, a trading sector. That was released in September 2020. We're now in April 2022, and the bill is still with the National Assembly. It has to go, the way normal bills are passed is, I think it's Section 75 bills, it's of the Constitution, that is. It goes to National Assembly, and the Portfolio Committee of that specific department drafts the legislation. The National Assembly then looks at it. And now we're still almost 2 years later, just in that initial phase with the bill. It then has to go to the National Council of Provinces to be considered on a provincial basis with the delegations, still national parliament, but the provincial house of it, right? And then, assuming that all goes well, because there's going to be a lot of heated debate around the Eastern Cape province, Limpopo and Mpumalanga, potentially all the provinces, right? Then it has to go off to the president to sign it. And only once it's signed is it enacted into law. And even then, you know, Ras Gareth Prince still promises, even with these developments, potentially to challenge it. So that's just the bill, never mind the commercial piece of legislation that might come about as a result. You know, so I think, you know, we're looking at another year for the bill to be passed into law. Then the commercial, let's say, call it the recreational cannabis bill, assuming that that's what they want to do. And act will take years. It will take another 2 or 3 years, in my opinion, at least, to have. But within that time, the Haze Club case will have been decided. There'll be other clubs that are being adjudicated in terms of the actual the bill, which will then hopefully be an act of parliament. So where the bill says one may cultivate X amount of, you know, people will interpret the bill to give force and effect, whether the state law advisor likes it or not. Once enacted, the Cannabis for Private Purposes Act, once enacted, will be interpreted by industry to give force and effect to the cannabis, the cannabis club space. There'll be a host of court cases that come about. And these things we can expect to start happening, I think, in the next 2 years, and like really kind of have a body of jurisprudence, maybe world leading in that sense, because our courts, we really like what our courts do here. regulation, straight up regulation of cannabis clubs, it's going to come through these precedents in the courts. It's not going to come from, it's not going to come through these, through the legislation. We're not, in my opinion, going to see in the bill cannabis clubs, if one wants to cultivate on behalf of another, this is how they do it. This is how the mechanisms work. You would need to have these types of agreements in place, a separate legal entity. We're not going to see it in legislation, I don't think.
Good. Okay. Amazing, amazing. That's it for all of our questions for today. I'm sure we're going to come back to you with a whole range of new questions coming from this. But yeah, we're good to
yeah, man, it's awesome. I mean, it's just lucky to catch up with you, Oaks, man. That's the bottom line for me. And to chat cannabis with you ultimately is a blessing. So thank you.
It really helps us to have a mind such as yours that can get so deep into the legal terms and make us understand it more clearly, you know.
I'm humbled.
It always feels very enlightening to have these conversations with you. So thank you for that, Brett.
I'm humbled and flattered. Thanks, guys.
And just lastly, for our viewers, go check out this manual for that Brett and Marlene recently published.
The framework for.
Yes.
Yeah, well, there it is.
Cool, thanks, Brett.
Beautiful.
For if viewers want to contact you, or do you provide consultancy services or anything like that for people in the cannabis sector?
Thanks for asking, Brett. My email address is brett_pollack@outlook.com. brett_pollack@outlook.com. Thanks for asking, Betsy. You can get in touch with me directly that way.
Add it on the screen.
I think thanks, man. Yeah, I think that's just the easiest way for now, and then we take it to WhatsApp and make it personal thereafter if guys are interested. I appreciate you asking for that. Thanks, Betsy. But yeah, we look forward to it.
Beautiful. Thank you so much for your time today, Brett.
For plants. For plants. Just for a plant. For plants. For plants. Huh? For plants. In today's time, we still get arrested for plants. For plants. They can over-police us for plants. They can't over-police.
What Jesus put there, they want to be law over